So, in the original penal code, which came to be drafted as a statute by Lord Macaulay in the early 19th century, included a section. Now, sedition as an offense came very close to a colonial power. The colonial power didn't want the natives express in any manner, whether in writing or vocally, any criticism of the government. In other words, in the colonial mindset, the state was synonymous with the government of the day, whether elected or unelected, representative or unrepresentative. They felt that we are governing, we are ruling over India, and any criticism of the government should be made punishable. Anyhow, it didn't creep into the Indian Penal Code 1860 for reasons that at least I don't know. But it was brought in 10 years later into the IPC as section 124 capital A. The words of 124 capital A as brought into IPC were very interesting. They made punishable any criticism of the government of the day. In other words, according to 124A, just the criticism of the government was enough for someone to be prosecuted for sedition. Now, criticism was described through certain very vague general terms like whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law. Now, you'll be wondering as to what is disaffection. It was as loosely understood by the courts of the day back then as it is by the language. The court said disaffection means lack of affection. So you must love your government. If you don't love your government, you are liable to be prosecuted. That was the concept as was brought in to the statute by the British. Now, we've all read a fair bit of the political history and how most of our political leaders who took part in the independence struggle suffered one way or the other, regardless of which thought they came with. You had within the Congress several segments of thought, and you had outside of Congress several segments of thought, but all of them suffered, and some of them also suffered for prosecution under 124 capital A. So as a result of which, when we became independent in 1947, the dominant political thought was that we must unshackle ourselves. We must unshackle ourselves from the vestige of the British era, namely, criticism of the government is something which is a part of freedom of speech and expression. A government of the day should be open to be critiqued, criticized, and should not be sensitive to its criticism, at least not such that it would start prosecuting people for showing disaffection to the government. When the Constitution was being drafted by the Constituent Assembly, we had a draft Article 13 in the draft Constitution. Article 13 ultimately became Article 19 in the Constitution as came to be adopted by the Constituent Assembly. Article 13 envisaged that sedition should be made as a qualification, as an exception, as an aspect that overrides the freedom of speech and expression. So, in the draft article as originally proposed, it was proposed that freedom of speech and expression can be curtailed by a law which deals with sedition. Then it was debated by the Constituent Assembly. And when it was debated by the Constituent Assembly, the thought that emerged was this, that sedition is a British relic. It should be removed from the draft Article 13, and we should not have the law of sedition as a qualification, as an exception, as a carve out, or as a restriction on the freedom of speech and expression. Now, this thought of removing sedition from draft Article 13(2), which became 19(2) in the Constitution as adopted, were carried the day, and in the Constitution as came to be adopted by the Constituent Assembly, we did not have sedition as an exception, as a restriction or a qualification on the freedom of speech and expression. But within a very short while, they say less than a year or just about a year, the story was to change.